So we're here with Andrew Geisterfer with Masuch Law, and we're going to talk about the difference between wills, power of attorney, and personal directive. So Andrew, can you tell us a little bit more about these three different types of documents?
Yeah.
What they do?
Thank you very much. That's also a great question, and it's greatly misunderstood. This all has to do with capacity. So a will is a document that gets written while you're alive and you have capacity, meaning that you understand what you're doing. But it gets triggered on death, and death means that you no longer have capacity. And so your will springs to life at that moment, and it says, these are my wishes of what should be done with my estate when I'm gone, when I've passed, okay? The other two documents, the power of attorney and the personal directive, are documents that say, hey, I'm alive, but I've lost capacity. And I've lost capacity meaning that I don't understand the consequences of my decisions. And as a result, the power of attorney is a document that I write, and it says, if I lose capacity during my lifetime and I'm still alive, I'm going to appoint Andrew to be my attorney, the person that makes decisions on my behalf. And those are decisions with respect to your estate, the things that you own, your bank accounts, your house, your car, things like that. The personal directive, on the other hand, is a document that says, I'm alive, but I've lost capacity, I've lost my mind, and I'm appointing someone to make decisions about my person, my personal health care, what my wishes are as to how I wish to live, and end-of-life decisions. And so the personal directive and the power of attorney are documents that are alive while you're alive, but you've lost capacity, but they come to an end once you pass. So once you pass, then those two documents come to an end, and the will springs to life to take the place of those two other documents.
Yeah, because a lot of people that come to the events are often confused as to when does the executor start and when does the power of attorney stops. And sometimes they would call us and say, hey, I'm the executor, but my mom is still here. Well, you're not until that day happens.
Exactly.
So that's always an area of confusion. So thank you for the...
And it's a really huge responsibility, and it's hugely important to understand the consequences that you don't have the ability to make any decisions whatsoever as an executor until the testator has died, okay? Because Andrew can have lots of money in the bank, and if I have capacity right up until the moment of death, I can choose to give it all away during my lifetime because the will springs up only when I die.
That's right. So how often would you recommend we review a will? Like, what are the triggers that would justify reviewing your will? Or if there's none of these big triggers, like how many years would you say you should wait in general?
Generally speaking, I encourage my clients to review their will every 5 years, or if there's a change in circumstance. So for example, let's use me. I'm married and I have 3 children. If my wife passes away, then I should check my will and says, what happens, does my will address that question of what happens when my wife passes? Okay, because my will says that everything goes to her. But if she's gone, then what? Okay? Or if our marriage, we have a marital breakdown and she's no longer my spouse, then do I want to name her as my executor and beneficiary? Generally, the answer is no. Okay? And so these are life events that get triggered that when they happen, then your will should be addressed as soon as possible.